don't know. Are we influencers?
Welcome to the Case Doctors.
Yeah, I don't think so.
Oh, I beg to differ.
With John Simon and Alvin Wolff.
I have a tough time influencing anybody anywhere. Homework.
The show where two of the greatest legal minds offer you advice on your cases.
Especially at home.
Okay.
Got no influence at home at all.
I understand.
The Case Doctors. We'll see you now.
Welcome to the Case Doctors. I'm your host, Christine Byers of Simon Law, and I'm joined by the Case Doctors, John Simon and Alvin Wolff. Now, we have some exciting news to kick off this episode. First, our podcast won an award at the Missouri Lawyers Media Legal Innovation Summit. We won for legal tech education.
I didn't know this was an educational program.
I was very surprised and very honored to get that award.
Good.
Same here.
It was
Same
a nice moment. It was a really nice moment. So, thank you to the viewers for putting us on the map there, and also for our listeners who watch our show on YouTube. Check out the new swag on John Simon and Alvin Wolff today.
We got to change you need to put your firm on the shirt. Apologize for that oversight.
You know, just get a Sharpie. Just write it on there.
Looking good, gentlemen, looking good. All right, let's turn to some of the civil cases making headlines and hear what the Case Doctors have to say about them. Our first one's going to take us over to California. And the plaintiff's attorney in this case disclosed Uber MDL documents, and the judge says he is on thin ice. So here's a little summary. Uber argued he should be sanctioned for allegedly using discovery in multi-district litigation over sexual assault liability to litigate other cases against Uber. In the enforcement order, the judge agreed with Uber and said that the plaintiff's attorney improperly used the MDL's discovery to create a spreadsheet, which then Uber claimed he later shared with his co-counsel in two unrelated cases against Uber over car accidents. So who's right here?
I mean, to me, at first glance, it sounds like it's not, confidential information, and it's information that would be discoverable. If it's discoverable in that case, it's going to be discoverable in individual cases. But the real question is, if there's an order, whether it's relevant or not, that's another issue. If there's an order from the court in that case saying don't share it, you can't share it.
I'm not sure why, if you get information in one case and your counsel on another case, why you can't use it. I mean, once the genie's out of the bottle, how do you put it back in?
I agree. It's sort of irrelevant because it's discoverable. It's already known. But like I said, it is going to depend on what the order said. I mean, sometimes, orders are more restrictive than they should be. I mean, it sounds like, from your reading of it, maybe there was not just the court order, but, a confidentiality agreement. What I've seen in cases is when we've had to sign them, what we try to put in all of them is something like, we're allowed to use it in the event we are counsel, as you said, in another case, because it wouldn't make any sense to, you're representing a new client, and you have information that's helpful to that client. I mean, how do you not use it?
Yeah, I mean, why should you have to reinvent the wheel?
Have you guys ever encountered a situation like this where you've been involved in a lawsuit against a defendant and have other cases against that defendant and then find something useful in the discovery and then use it?
All the time. Happens to us all the time. And, what we'll do is talk to counsel and, have the court modify the order in the case. If we have an order that prevents us from using it, we go back and allow us to use it in the other case. Or best thing is just to ask the same discovery in the second case that we did in the first case.
Yeah, you find that in hospital cases all the time. And, they always want confidentiality orders. I said, you really think I'm going to open up a hospital and use these rules and regulations to run my hospital? I mean, what's the secret about it?
I had an elevator case at a hospital, and the hospital was one of the defendants, and they argued confidentiality of information related to the repair and maintenance of the elevator.
Silly.
Yeah, it was ridiculous.
All right. Well, let's move on to our next hot topic. Now, as we all know, Grubhub is one of our popular food delivery services, and this lawsuit says Grubhub failed to protect private information from breach. The lead plaintiff said the company's, quote, negligence and insufficient data security allowed cyber criminals to easily infiltrate its network and access, quote, everything they need to commit identity theft and wreak havoc on the financial and personal lives of thousands of individuals. Grubhub is bringing in more than $2 billion with a B annually, and the suit says it could have afforded to implement adequate data security prior to the breach, but deliberately chose not to. What do you think about the merits of this case?
I like the liability, not sure about the damages.
And I've seen in those cases, one of the remedies for that is that the offending defendant has to pay for monitoring for the plaintiffs for several years to make sure there's not any unauthorized use of their credit information.
Yeah, that would do it.
You know, you get Equifax for 3 years or whatever these companies are called. That's probably the remedy. Everybody gets a 25-cent coupon for their next delivery of General Tso chicken,
25 cents off their next hamburger or whatever.
and the lawyers make $25 million. Splits 37
Sounds like
ways.
you like class actions. Or had a bad experience with class.
I've never understood them, really, for the most part.
There are good ones, and there are ones that aren't so good.
Well, these coupon ones I really kind of don't understand. I mean, we just got to check for 13 cents on a case.
Yeah.
13 cents.
13 cents.
Did you have to fill out paperwork to get the 13
I
cents?
think it was automatic.
Well, there you go. Didn't cost you anything.
No, it didn't. But it cost them 79 cents for a stamp to send the check.
How does that work?
It makes no sense.
How does
So
that
what
make
was
any
their
sense?
fee on that 13 or on
I
the
have
case?
no idea.
Yeah.
I said, we have a check for 13 cents. And I cashed it, and that was it.
How did you spend it?
It was my wife, so I just put it in her account. So which account would you like it in? Your checking account
Split
or
it
your
up.
money market?
Diversify, split it up.
Thank you, gentlemen. Time now to turn to our email inbox for the cases our viewers have sent in for the case doctors to diagnose. Now, just so everyone knows, we're not going to reveal where these cases came from. We're not going to name any names or firms to protect the confidentiality of the cases. Instead, the case doctors are going to focus just on the issue in each of them. So as they say, the case doctors will see you now. Our first viewer is contacting us about a viral lawsuit. My influencer client glued her face shut on TikTok. My 23-year-old influencer client purchased a knockoff facial suction tool from an overseas website. She used it live on TikTok without reading the directions and the warning on the packaging.
What? A face suction tool?
A facial suction tool.
You ever heard of that?
You know, I got cardiac life support training the other day, and there is something you can put over your face to remove food if the Heimlich doesn't work.
Oh, okay.
I mean, it's a suction that goes over the face, and you pull on it, and it creates a suction so hard it can knock you down.
Is that what was happening? They were choking on food?
No, I think this has more to do with plumping your face, and most notably, I've seen them used to plump lips. You literally put, yes, there you go, Alvin. The pouty lip look. So she used the highest setting, which left severe hematomas all over her face. And she now claims the device is inherently dangerous despite not following the directions.
Well, why do they have why do they have it adjusted so it can go up high enough to cause injury? I guess.
That would be a good question. This attorney is asking, can I hold the seller liable when half of the disaster was streamed in live real time?
I don't think that makes any difference to you.
No. You know, is it a permanent injury? I mean, I think of people when they do something called cupping, and you look at their back after
Right.
they cup, and they got bruises all over their body.
Right.
And eventually they go away. I mean, if this lady sucked her face off, that's another story, and then she's going to have to sue the manufacturer in China.
Yeah,
Which is
that's a whole
another
nother deal.
problem.
Yeah, that's another problem.
I mean,
Where'd she buy? Did she buy it from a brick and mortar store?
No,
Amazon?
she bought it online.
Online. There you
Temu.
go. Yeah.
There you go. It was a Temu purchase. Now, what she's arguing is that she is, she's an influencer, but now she's being mocked online and suing the importer for those damages to her.
Oh, the damages for her reputation. Okay,
The defense
all right.
is arguing contributory negligence and influencer stupidity.
Well, she was stupid to buy their product and use it. This is what they're saying.
Well, and it reminds me of
work.
trying something in the courtroom for the first time in front of a jury without testing it first with the doors closed.
Not a good idea.
Have you guys ever seen that happen?
All
Yes,
the time.
Yeah.
All the time.
So an attorney that my former partner was trying a smoke alarm case, and he was representing the plaintiff, and the allegation was the smoke alarm was defective, didn't go off, and our client was either burned to death or severely burned, and it had melted, sort of melted the smoke alarm, and the defense attorney handed the smoke alarm to their witness, or maybe it was my partner's witness. In any event, I wasn't his partner at the time. He was a young lawyer, and he claims that the expert on the stand in court forced it open, pried it open, and there was no battery in it, and it hadn't been.
Oh, dear. Oh, no.
So that wasn't a good day.
If,
That
the,
wasn't a
if
good
the
day.
glove don't fit, you must have quit.
Yeah. So, yeah, I would, so it's her reputation. You know what's going to happen? I think more people are going to watch her program now, good,
It's
bad, or
true.
otherwise. Her viewership's going to skyrocket, and here we are talking about her on our Case Doctors segment,
Right.
right? She's made the news, right? Or she will make the news, I guess. But yeah, I think, can you prove those damages? I guess. How? Not sure. But, certainly, I think, a product that's made to be, she was using it the way they intended her to use it, right?
Right.
It was a foreseeable use of the product. Even a foreseeable misuse is actionable. And I think if the thing really had a setting high enough to cause that kind of harm, people shouldn't be using it. It's probably a defective product. The tougher issue, as Alvin said, is where are you going to file the lawsuit if it's purchased online and it's a company from China or from some other country. You got that issue. You're going to end up at best in federal court somewhere. And are your damages significant enough? And it sounds like the attorney's angling for damage to her business reputation, which that may work. It depends on what the evidence is, I think.
Well, if she has 7 million influence followers before and 9 million now, she's going to have a tough time proving damages.
Yeah, and so and it's I guess the embarrassment. Is that what it is? I mean, I don't know.
I don't know. Are we influencers?
Yeah, I don't think so.
Oh, I beg to differ.
I have a tough time influencing anybody anywhere, home, work, especially at home. I've got no influence at home at all.
I understand.
Another case comes to us from an attorney who says, my client got pregnant after using a 3D printed IUD. My client ordered what she thought was a state-of-the-art contraceptive device from a startup health tech company. Turns out, it was a 3D printed IUD prototype sold through the subscription-based biohacker newsletter. She's now pregnant and wants to sue for product liability and emotional distress. Here's the kicker. The product came with a digital waiver, but it was buried in a 40-page NFT-linked document she never opened. What theories of liability can I use here? Is this a failure to warn case, a design defect, or just a really weird informed consent issue?
You can start on that one.
I tried a wrongful conception case where a doctor claimed to tie the lady's tubes and didn't.
Really?
And she got pregnant and she had an emotional breakdown and was hospitalized. I tried it in St. Louis County and I got a verdict for that. On the other hand, there's a statute in Missouri that says you cannot file a lawsuit for wrongful birth or wrongful life. And I went to the Supreme Court on that on a case for a child born with no arms.
Really?
And there was an ultrasound which showed, well, I don't know how you can show that something doesn't exist, but there were no arms on the ultrasound. And I tried the case, got to the Supreme Court, and told the judges that we were there for the mom's emotional distress, because one time I saw a Twilight Zone where a lady gave birth to a kid that was completely deformed, and she freaked out. And I thought about that on the spot, where I was told, well, what are her damages? I said, emotional distress. And we won. I got to try the case and got a verdict in St. Louis County on that. But the damages are significantly limited. So she's either got, wrongful, it's kind of like a wrongful sterilization case. She could make a claim for that, but she can't make a claim for wrongful birth or wrongful life.
So what about the consent issue?
Nothing is 100%.
Yeah, yeah.
I mean, you get, even when you were a teenager and you were buying condoms out of the gas station vending machine for 25 cents, there was a warning saying these don't work.
You used the 25-cent ones?
That's all I had. All I had were quarters.
Should have used the 75-cent ones, buddy.
They didn't have the expensive ones at Carl Bolch's.
Oh, goodness. Wow. That's good stuff,
So,
guys.
well, I mean, I would agree with what Alvin said. It sounds like, we got a case if you're not in Missouri, right?
Maybe, I mean, the states are differed on wrongful birth, wrongful life. Missouri, there's a statute. Wilson versus Coonsey was the case. And the other thing is the wrongful sterilization. I mean, there's negligence for that. If she's got emotional distress, but she can't say, I'm having a kid because of that, because that would be wrongful birth.
Right.
So it would have to be a mental distress kind of claim for any damages.
Fascinating.
Complex issues in that case. That's got, and even if you're able to pursue the claim, I think there's issues with the jury and how people look at that, and because you're really going to court being, suffering emotional distress from having a child. I mean, I'm sure she loves her child and cares for him. You know what I mean? It's
I mean, the damages in both of those cases, even though I got verdicts, they were not huge. But back then, you could try a malpractice case in a file that was a half an inch thick. It doesn't happen anymore.
That's fascinating that the doctor, she went to get her tubes tied and it didn't happen? What did he do?
Well, apparently, he put some rings. He said he put some rings on the fallopian tubes, and they fell off. But my expert said if he would have put the rings on the tube and they would have fallen off, there would have been an indentation or a scar or some sort of impression showing that he did it.
and so he really didn't do
And
it.
he put it on the round
So
ligament.
she had a procedure and he just didn't do anything?
He put it on the wrong ligament rather than the fallopian tubes.
Oh, so he put the rings somewhere else, but the fallopian tubes.
This was the funniest case because
Oh dear. Look at that smile. When that smile comes out, I'm like,
my
we're
expert
going to
is
get...
testifying, and she says to him on the stand, do you know Doug Towd? Yes. How do you know him? I threw up on his shoes once. And he actually said this to the jury, and everybody started laughing.
Oh, wow. That's interesting.
It was,
So where do you go from there?
it was cross-examination. It wasn't my problem. Don't ask a question you don't know the answer to in court. You can do it in a deposition, because that's discovery.
But don't do it in court.
Well, I mean, there's exceptions to that rule, but that's a pretty good rule of thumb.
I agree wholeheartedly.
Unless the witness just is not answering the question. And if it's not going to hurt you, I mean, one time the witness was testifying. I said to him, "What's my client's name?" And he got out his folder and started going through it.
That's bad news. And
Yeah.
I've had that happen more than once. And I ask it in trial all the time.
We had my son, Johnny, and I were trying a case. It was a death case in the county of a 27, 28-year-old woman. And that's what he asked with the corporate rep on the stand, who was a real jerk that he was terrible. And That's what he asked, and he arrogantly said, and he didn't say, what's my client's name? He said, who is, and stated the client's name. And do you know who that is? And he said, I don't know, kind of like that. And
Didn't help him.
didn't help him at all. The jury talked to us about that after the verdict.
Wow, interesting. Okay, gentlemen, that will do it for this episode of The Case Doctors. If you have a case that you would like the Case Doctors to dissect, send us an email at cases@thecasedoctors.com. And here's a QR code that will take you directly to our contact page. Once again, we will be keeping all names and cases confidential. Thanks for joining us, and we'll see you next time on The Case Doctors.